is the real estate condition report. If you are taking a listing, this is very important on how you present this to your seller. We've had a few situations this year that we're bringing in attorney reviews or attorney questions. And so we started realizing that maybe we needed another review of the real estate condition report so that it cannot be used against our clients, either the seller or the buyer. So if you are a buyer's agent, you're going to receive a copy of the real estate condition report when you write an offer on a listing. And if you are the listing agent, you are going to bring this up to your seller prior to putting the house on the market. So there's some very important things that we need to pay attention to. And a lot of that's going to be based on some of the questions that came up in these issues this year. So I am going to go to the condition report itself. I had a couple of weeks ago, I did do a short real estate condition report slides at the team meeting, and I will review those slides at the end of this. But what we're going to do today is basically generally go over what the real estate condition report is and your responsibilities as a listing agent. And then we'll talk about what your responsibilities are as a buyer's agent when you receive one. So a lot of times, and I know, when you get one of these forms in your listing packet to show to your sellers, you basically say, you know, your comments to the seller is this is an important condition report that you must fill out. There are cases where you can be exempt from filling it out, and we'll discuss that at the end of this presentation. But right now we're going to talk about how you present this to the seller. Number one, this is a state law. This is not a real estate law. This is a state of Wisconsin statute 70902. And it is required of everybody selling a house, whether they're for sale by owner or they are working with a real estate agent. So they are to disclose the condition of that property as of, and important to put in the day, the month and the day and the year in this form. You are not to enter anything into this form. It should all be filled in by the seller, either in handwriting and giving them the actual paper form, or you can do it digitally. Zip form, I guess, now has a way to digitally fill in the condition report, giving it to the actual seller. I find it better this is one of the few pieces of paper that to actually give them the paper product of it, where they can take a few days to review it and make sure that they've covered everything that they know about the property.
Really quick, just make sure everybody, can you guys please mute yourselves? You're getting some background noise.
Yeah, I can't find it.
Joan, do you know how to mute? How do you know? Do you know how to mute?
I do, but I can't find it.
Okay. All right, we'll keep going.
Oh, I know. Okay.
Can I get a slice of pizza? Cheese pizza. Yeah.
Don't give me.
Is Lindsay right there?
Just cucumbers and
no,
cheese.
she isn't there now.
Okay. Okay.
Let's get back to this. Okay. Yeah, don't get me off filter now. There. Okay. All right. So this is, as I said, this is a state law that they have to fill this out. And it is this disclosure on what they know about the property. It says that they are to put down any information that they are aware of, either actually aware of or in the past that they are aware of. And down here, it means aware of means the owners have knowledge or notice, have been given notice. This little section right up here at the very beginning is very important too. And I want you to make sure when you're talking to your seller to point this paragraph out. A buyer who does not receive a completed copy of this report within 10 days after the acceptance, 10 days after the acceptance of the contract of sale for the above described real property has the right to rescind that contract. So that's there for the reading, that's there for the seller to realize this, that if he doesn't get this in a timely basis, and you have an accepted offer, but this buyer still has not received this completed form, the buyer can walk. The buyer can say, I never got the condition report within 10 days, I'm out of here. So make sure that the seller understands this. And this is important because this was part of one of these legal issues that came up this year. The agent cannot advise the seller on this paragraph. All the agent can do is point out this paragraph to make sure that the seller reads it, but you can't interpret it, and then that becomes like legal advice. So you got to be careful there. Just make sure your seller reads that the buyer can walk if he doesn't get the condition report in an amount of time. Real estate licensees may not provide advice or opinions concerning whether or not an item is a defect for the purposes of this report or concerning the legal rights or obligations of the parties to a transaction. This again is warning the agent. It's not up to you. It's not up to you to advise whether something is a defect or not. It's not up to you to assist the seller in filling out this form. And that was part of a legal issue that we have. We had an agent had to be deposed on what their activities were in helping their seller fill out the condition report. This is very important. It's up to the seller alone. Parties may wish to obtain professional advice or get an inspection on the property, and also to include appropriate provisions in a contract between them with any advice, with respect to any advice, inspections, defects, or warranties. So if they have any reports, any inspection reports, they can add that to the condition report, or they can attach it to the condition report for the buyer to see, or they can just fill out their condition report based on previous inspections. And in this form, aware means the owners have knowledge or have been given notice. And that would be like a previous inspection or something. In this form, it means, and it defines the word defect again for all. Anything that would have a significant adverse effect on the value of the property, that would significantly impair the health or safety of the future occupants of the property. So those are considered what is a defect, or that if not repaired, removed, or replaced, would significantly shorten or adversely affect the normal life of the premises. This is for the seller's benefit, for them to read what the definition of a defect is, and for them to help fill out the condition report. Again, agents, hands off. In this form, owner means the person or persons, entity, or organization that owns the above described real property. An owner who transfers real estate containing 1 to 4 dwelling units, including a condominium unit, and timeshare property by sale, exchange, or land contract is required to complete this report. In this report, an owner can be the exemption to this, an owner who is a personal representative, a trustee, a conservator, or a fiduciary appointed by or subject to a supervision by a court, and who has never occupied the property. So they have to be one of these and have never lived in the property, is not required to complete this report. There's a big misunderstanding that agents say that if the person has never lived in the premises, they are exempt. That is not true. They have to be a personal representative, trustee, conservatory, or somebody appointed by the court and have never lived in the property. An owner who transfers property that has not been inhabited or transfers property in a manner exempt from a real estate fee is not required. So these are two other exemptions to filling out the condition report. New construction. Nobody's ever lived there. Not just the seller has never lived there. If no one has ever lived there, they are exempt from the condition report. Or if it is being transferred, say, from a father to a son, family, then you're not required to fill out a real estate transfer fee. Then that property is also exempt from the real estate condition report. This is the important part. And this is the part that a lot of agents, even very experienced agents, have either not learned or have forgotten. The owner represents, to the best of the owner's knowledge, the responses to the following questions that have been accurately checked as yes, no, or NA. If the owner responds to any question with an S, the owner shall provide in the additional information area of this form an explanation of the reason why the response is a yes. So you just instruct your seller, any box that you check S, then at the bottom of that section, there is this place for comments, and explain why you checked yes in that part. If the transfer is of a condominium unit, the property to which the form applies is the condominium unit, the common elements of the condominium, and any limited common elements that may be used only by the owner of the condominium unit being transferred. So that's very important if you are listing a condominium and how you direct the seller. They don't have to fill out a real estate condition report for what's going on in the roof of the entire condominium building. Only the areas that they use and their unit. The owner disclosed the following information with the knowledge that even though this is not a warranty, prospective buyers may rely on this information in deciding whether or on what terms to purchase the property. The owner hereby authorizes the owner's agents and the agents of any prospective buyer to provide a copy of this report and to disclose any information in the report to any person in connection with the actual or anticipated sale of the property. Caution. This list of defects following each question below are examples only and are not the only defects that may be properly disclosed in response to the question. So if there's something that isn't on the form, but the seller realizes it is a defect with the property that they have noticed or they are aware of, they must add it to this condition report. Now, as I said, because this is on the first page with the blanks where you fill in the address, you don't fill them in. The seller fills them in either digitally or handwriting. Because this is a first page and it looks very much like a list of contents, a lot of agents skip this page. And it's something to make sure that you review with the seller, not advise them on anything, but to review with the seller about the owner's information. It's this first page that agents miss that sometimes get them in trouble with a pending lawsuit. So this is why we want to bring this up this year, not only to a contract training, but also to team meetings so that our agents are fully prepared and understanding the RECR and how you use it. And as I said in that team meeting, it's referred to as the RECR because it's an acronym, but it really can be a wrecker of your business if you don't follow what we're talking about today. So do look at this as a very important document. It's a very timely document, and it is a very reliable document. So what we're going to do is just briefly go through. I'm not going to read all the sections, but I'm going to just do a general take on each section and the importance thereof, and how you describe this to the seller is repeatedly saying, write down everything, anything that you are aware of. You as the agent cannot advise your seller, oh yeah, I would call that a defect, or oh no, I wouldn't call that a defect, or you don't have to mention that. Don't ever say that. One of the lawsuits that we have been threatened with is because on the other side, not on our side, but the other side, the agent told the seller they don't have to put that in. He didn't think it was important. And it's become an important aspect of a lawsuit right now. So again, agents hands off, don't provide advice, but make sure that the sellers are fully aware of what their responsibilities are when they're doing this. So the first section is regarding obviously structural and mechanical. And this is very important. It's probably the heart of a house. And in terms of its value and its survivable value, whether things need to be repaired so that they continue the life of the house, or whether there's any defects of safety or health concerns. Again, seller doesn't have to be an electrician or an engineer to fill this out, only what they're aware of in their house. So again, when it talks about the beginning of each line, are you aware of defects? Are you aware of defects in the roof? Are you aware of defects in the electrical system? And then they give some examples. The seller may have a situation in their electrical system that they're aware of, but not necessarily one of these examples. Again, they click on the yes, and then they go down to this section where there are explanations of yes responses and type them in there or write them in there. So as I said, each sentence starts, are you aware of the defects in each one of these? This is why I believe it's better to give them the paper form so they can actually take it and review it with other family members, or going back and looking at reports and things that they have. The overall general discussion to have with their seller is that the most important thing to protect them is to disclose. Disclose, disclose, and if you haven't disclosed enough, disclose some more. Because failure to disclose is probably the most common lawsuit that a buyer who buys a house and then moves in and realizes that there's a problem, a defect, finds evidence that that previous owner knew about it, had contractors in there about it, and didn't disclose it, they are ripe for a lawsuit. So you cannot advise your client of anything legal other than saying, all I can say to you is disclose, disclose, disclose. Some agents, I used to do it, I think it's a good practice when they are looking at some of these things, say, are you aware of defects in the heating and air conditioning system? Maybe the furnace went out a year ago or half a year ago. I would instruct the seller to consider things that had been defects but have been repaired. So you may want to put down yes here, and then in the comments say furnace failed in summer of 21 and has been replaced with a new furnace in August of 21 or something. You can use this form as not only current defects, but former defects in the last, I would say, year that have been repaired or replaced. And this report then becomes not only a disclosure of defects, but a disclosure of the maintenance and the repair work that the seller has done. Not all agents do that. A lot of agents just advise the seller to only put down what they think are defects, current defects. So there's a section beyond mechanical instruction. There's a section on environmental, and that talking about mold and electric high wire properties, asbestos. Again, a seller isn't going to know that unless they've had something inspected or relieved or put out in front of them with a report. But again, you don't give that alternative to the seller other than put down what you're aware of. You know, if you think it's asbestos, you can put a yes here, say yes, not proven asbestos, but it seems to be asbestos containing materials or something like that. Again, always fault toward disclosing more than less. And I think that's probably the only advice that isn't legal that you can give to your seller. Under well, septic systems, storage tanks, you can put NA in these boxes. If there's no well, septic system, or storage tanks in that property, make sure that the NA is filled in. A lot of agents try to skip that if there isn't. I'm telling you, another factor in a lawsuit that may be pending for us is the fact that the agent, our agent, let the seller skip some of these. So he didn't mark anything. He didn't mark yes, no, or NA on a couple of things. He may have just overlooked it. But the seller didn't, the agent, listing agent didn't review it to make sure that he saw that everything was filled in, missed that he had skipped a couple of them, and that is now being used against our agent for not having a completed condition report. I'm telling you, if it isn't done right, it can get picky. A next section is on taxes, special assessments, and permits. And this is important for all properties, knowing what they are aware of. Going back to that first page, aware just means having knowledge of or being given information, notice of something. So if they're aware of special assessments, any permits, any changes in taxes, they are to fill this section out, and any yeses, make a comment in the blank lines. The next section is land use. Are we in a subdivision? Does it have a homeowners association? Are there conservation easements on the property? Again, you just point out the importance of this form, but you do not help your seller fill it out. Are there any questions so far in this that you have about working with your seller and filling out this condition report? You can unmute yourself if you have a question.
I have a question. What if the seller isn't aware of or doesn't know what the item means, or doesn't know if they, they have a septic or, whatever? How can you assist them with pointing them in the direction, or how does that work if they just don't know?
Right. Well, since the agent normally isn't a structural engineer, nor is the seller a structural engineer, nor is the agent usually a plumber, or nor is the seller a plumber. When you get into specific areas like this, neither the agent nor the seller is an expert. And I think you're right then to reach out to somebody and find out for sure. Say they have wrapping on the pipes in the basement. They're not positive they're asbestos, but they kind of look like asbestos. Maybe it's up to the seller to take the action step of getting it tested and to know for sure when they're filling these things out. Or they can just say they're not aware of it because they've never had it tested, they don't know, and they would leave it up to the buyer to make that determination. So again, it's up to you as the agent to just always stress the importance of disclosure as much as you can. But it does have to be something they are aware of or have been made notice of. A classic example is the house, say was on the market and a buyer came in and had it inspected and then backed out due to inspection items. And they could be on something totally different than the issue that came up in the condition report. And, but anyway, now the seller has in his possession a copy of that inspection report. What do I do with this inspection report? Well, I don't like some of the things that were found out during the inspection. I don't agree with them. You know, I don't think I have asbestos, or I don't think I have, you know, plumbing problems or electrical problems. And yet here is an inspector who has put in his report that these conditions are here in the house. What is the seller to do? Well, you as the listing agent say, disclose, disclose, disclose. You can get another contractor or another engineer or somebody in to bring in another opinion, or you can just attach that previous inspection to your now real estate condition report saying, here, go for it, read, this is what the previous inspection had, you know, and that's fully disclosed. Or the seller has the option to pull out the amendment to the real estate condition report, and that is an actual form. The amendment to the real estate condition report where you add items that maybe were found during an inspection that the seller was not aware of before. So he's now been made notice of these issues. He is then instructed to pull out the amendment to the condition report and add those items onto it. That probably is the better way than sharing the entire inspection report. But the worst thing your seller can do is not to disclose something that they learned in an inspection report. They should disclose it in one way or the other, either share the inspection report, amend the real estate condition report, repair and replace those things that were found in the inspection report, and then make notice of that. But again, you can't say, oh, that's definitely a defect, you should add that, or that's not a defect. And I'm sure Steph gets these calls, and I get these calls a lot, either from the buyer's agent or from the listing agent when these issues come up, hopefully before closing and not after closing. You know, something like this, are you aware of boundary or lot line disputes, encroachments, encumbrances, including a joint driveway? Well, I think most sellers would know if they have a joint driveway or not, but they may not know about encroachments or encumbrances. So they say, no, I don't know of anything. It may come up when they're getting ready to close. Title finds some of these maybe encumbrances on title, and then everybody's made aware of something at the same time. But the seller isn't, you know, expected to know things that he may assume or he may have heard about, but doesn't actually know, doesn't have actual knowledge or been notified. And if he's reading this and he's not sure, I think it'd be a smart seller that would actually call the municipality and find out. Always better to disclose. So it gets down to the end about under this section of condition of the or land use. There's a lot in here. It even gives links to find out if this property, say, is in a peer violations area. Riparian rights, this is the only time you ever see that word after your license, pre-licensing instruction, but that is an issue that sometimes can involve a land dispute if there are riparian rights to the property. Again, you can direct, to your question too, you can direct the seller to different places where they can find this information out about the property, or they can basically just check no and say, I don't know, I have no idea. So any additional information, this gets to, have you filed any insurance claims relating to the damage to this property in the last 5 years? Are you aware of a structure on the property is designated as historic? Talk about a lawsuit. We've had a lawsuit, or aware of a lawsuit, that the seller wasn't aware of that or didn't realize the importance of it being designated as a historic property. It's smart for the seller to do research on what they're selling, but if there are certain things they don't know, they don't know. But they're going to have to prove that they didn't know it, and that's an issue. Other defects may include items such as drainage easement grading problems, excessive sliding, settling, earth movements or upheavals, any other defect of material conditions. These hidden little questions in here can become a pothole for your seller unless the seller really takes this entire form seriously and pays special attention to each question. And all my years of real estate and picking up seller condition reports, getting ready to write an offer, I've seen thousands of them that are filled with no, 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 no. And then the seller signed it at the end. So it's like a house may have been built in 1932, but for some reason it is perfectly clean of any defects. Well, it's just anytime I would see a condition report that was just a slash of no and then the signature, it gave me a red flag, and it made me more diligent to get a better inspection on that property, because obviously the seller was not going to disclose. And hopefully we didn't have to go back to the seller. In G4M, this is where it gets into the FERPA situation. If the seller is the owner a foreign person, if they are a foreign person, they do have to register that and do a yes and explain that they are, because they may be subject to a tax based on the sale of their house if they are a foreign person. So understand the FERPTA, it's in the offer. Title will help you with that. If you are writing a property where the seller is a foreign person, you will get assistance from the title companies on what to fill out. Here at the last page, it talks about the owner has owned the property for so many years and the owner has lived in the property for so many years. Make sure you don't fall into the mistake that a lot of agents do with thinking, well, if they never lived there, we don't have to fill this out. That's not true. You don't have to fill it out if nobody's lived there, if it's brand new construction. You don't have to fill it out if it's a trustee or a person designated by the court. But if the owner is the owner, whether they live there or not, they are responsible for filling out the condition report. Now, there are a lot of instances, and I've had two most recently in listings that I had, where the owner owned the property, definitely was the owner, but it had either been rented for years or they bought it as an investment, and it was either sitting, the owner never moved into it, and it's just been sitting to sell it, or it's still in that sort of capacity, but the actual seller has never physically lived in the property. And in that situation, especially the one where, say, it's been rented for years and years and years, while the seller still owned it, the seller may say, I really don't know anything about that property. My tenant has been very diligent and they've taken care of it. My tenant and I don't really talk except to give me the month rent. I don't know a thing about this house, even though I own it and I've never lived in it. I don't want to fill this out. I don't want to say anything about this house, whether I know anything or not. I could say I don't know anything, but again, that would be thing that's important. Well, there's a separate form that you can get through Zip Form that is called the refusal to fill out the real estate condition report. And it's just saying, the seller saying, okay, I own it, but I don't want to be responsible for any knowledge that I may or may not have about the condition of this property. So I'm not going to fill it out. So what you do is send, you put out there the condition report signed by the seller and the refusal form also signed by the seller. It also gives, he has to give a reason why he's refusing to sign it. I've had to do that with 2 listings and it didn't flag the listing at all, totally understood. But that form of refusal form has to be in place of them not filling this in at all. So again, it gives a little concern about sex offenders. We're not going to talk about it. The seller's not going to talk about it, but what they do is refer them to this link where the buyer can check and see if there are any sex offenders in the neighborhood. So this is where, at the end, this Wisconsin statute requires owners who, prior to the acceptance of a purchase contract or an option to purchase, obtain information that would change your response on this report to submit a complete amended report or an amendment to the previously completed report. So there is a separate form, I don't have it popped up here, that's called the amendment to the condition report. I prefer that to be used rather than changing the whole condition report because it gives a paper trail. Say on November of 2021, this was the condition report I filled out. I found out about some extra things about the property. Since then, before I have a new buyer, before I have an acceptance of an offer, so I'm going to fill out the amendment to the condition report attached to the condition report. It gives a nice paper trail of what I knew then, now what I've learned now, and here's my full disclosure. Any questions from any of you based on this so far and the importance of this?
Yeah, I have a quick question.
Sure.
Mostly just kind of like, so I understand, I'm just, I guess, trying to think about like anticipating questions from future sellers and just trying to stay away from not advising, but just wanted to like, so I've heard some people say like, you know, just because you have a lot of yeses on the report, like buyers might actually find that more like comforting because you're being upfront with things, but like that seems like it could veer into like, oh, like when in doubt, disclose, you know, buyers find comfort when they think that the seller's being honest. Is that like kind of too far into the advising, or is that kind of on the right side of the line?
Well, I think as far as advising, you're just giving the general thing is you're never going to go wrong with disclosure. You may turn off some buyers by disclosing too much. And the sellers are always going to be anxious about that. You know, if I put that down, they're going to look at this and not want to buy my house. You have to get over that feeling because you say in the long run, it's much better to sort out the buyers who will accept your property as stated in this condition report, weed out the buyers that would not be excited about one of these defects. But you're so much better off having that disclosed than to go to closing and then the buyer finds out later what this that this condition is there and can prove, because the proof of the burden of proof is on the buyer. The buyer has to prove that the seller knew about it before the closing.
Yeah, so it just kind of seems like if a seller just kind of keeps coming back to you with questions of like, oh, we're not sure about this, then it's just like, you know, when in doubt, disclose, and then like move on and just kind of have the same line for every question. Okay.
Exactly. But if there's something they really don't know, I mean, I don't know that the wall, that the walls are out of plumb or something like that. I've never had it tested. I've never had an inspector in here. They look they look straight. There may be some cracks. The other thing that the seller can get into is the extent of which sometimes the sellers want to hedge a disclosure of a defect. Say they get, every time it rains, they get a trickle in the basement floor, probably to the drain in the basement. And they don't consider that a big deal. It's not a finished basement. It goes right to the drain and it doesn't disturb anything. And so they may say in the condition report, you know, slight trickle of water after heavy rains or something like that. And the buyer who's reading that says, well, you know, I think I can accept that. It's not a finished basement. It's just going straight to the drain. And then the buyer moves in and they don't necessarily finish the basement, but they start putting boxes down there and they start putting personal objects in the basement. And there's a good rainfall and swoosh, you know, talk about riparian rights. There's a stream going through the basement and getting the boxes wet and getting the bottom of the washing machine wet and things like that. And that's a little different than what was disclosed on the real estate condition report. It wasn't a small trickle after rain. It was a lot of water after rainfall. That can be a situation where this buyer may be able to go after the seller and saying, you didn't disclose the extent of which there is water in the basement. You tried to downplay it by saying it was a trickle of water, where since I've lived here, it's rained 4 times and every single time it's been significant water, and I've had to clear out storage in the basement and protect my washing machine. And, you know, that's the extent of which that these sellers explain on these comments of explanation of yes responses has to also be notified to the seller why it's important. Don't hedge it. Be honest about what you see, what you've experienced while you've lived in this house, because pretty much so the new buyer is going to experience those same things. And then he's going to look back at the previous owner and say, why didn't you tell us about this? So it's not only make sure that you disclose, but that you honestly disclose the extent of which too. And again, we see the consequences, you know, and as compliance brokers, and I was a manager for 20 years, we saw the consequences when sellers would not disclose. And those usually involved a man with a hat on his head that said attorney, or one with a hat on her head that said attorney. So it is, you want to protect your client. You don't want to advise your client on legal issues, but you want to protect your client. And if they don't believe you, have them talk to a real estate attorney. Ask a real estate attorney about the importance of disclosure. Ask them about a particular situation. You know, should I put this down in my real estate condition report or not? The attorney will tell your seller what you can without advising them. But this is why I want to go a little deeper into the real estate condition report and not just toss it off as one of the documents that we have to fulfill our checklist. It can be very important as far as a protection for your seller and protection for you and protection for Keller Williams. Now, going back to being the buyer's agent, what do you do? What are your responsibilities as a buyer's agent when you get a copy of this condition report and you give it to your buyer along with writing the offer? What do you do? First of all, you explain to your buyer what this report means, what it says. You can go over the first page, what the seller's instructions were to fill it out, and then you have your buyer sign it down here. This is a little bit of confusion. Sometimes buyers won't sign that because they think that they're accepting all these conditions. It doesn't mean that. It says the prospective buyer acknowledges that technical knowledge such as that acquired by professional inspectors may be required to detect certain defects, such as the presence of asbestos, building code violations, and floodplain status. So it's really, that's stating that the buyer really should rely on an inspector for actual technical knowledge of what's in the house. The signature on the real estate condition report is just an acknowledge that they've received a copy of it. And the date, which is important because if it goes past 10 days after acceptance, the buyer can rescind. So this signature block is for the buyers to say, okay, I got it. I got the condition report and here's the date. And it shows that I was within the 10 days of acceptance. So again, it is something that we really want to stress the importance of, but also because we've seen some real life consequences regarding the real estate condition report, we want to be really careful that all of the agents understand its importance. Any questions on this? I'm going to quickly go to the slides that I used in the team meeting a few weeks ago, just to reemphasize what is memorable with our use of this real estate condition report. So, of course, it's not here. No. So I did have it up. I don't know where it is.
Once you do have them up, you will need to share the screen again.
Yeah, but it's not on my list.
Hmm.
Okay. I was trying to do this without Steph's help today. Right. Well, what I'm going to do, because it's just time, those of you who are on this call, I really appreciate it. It's something, again, that we're just going to continue to work on. And I will send to you the slides that I seem not to find. And there are just 5 slides that are the important things regarding the condition report that I covered in the team meeting. So actually, Steph, you might be able to find it on slides, Google Slides.
Let me see.
Okay.
Mm,
Any other questions that I can answer in the meantime?
Can you hear me?
Yes.
It's Judy
Mhm.
Pemberton. Say,
Hi,
I
Judy.
have a case where a brother passed away during the holidays, and so his brother is taking over the estate. He's been named the personal rep. And he is aware that all the windows in the condo need to be replaced. What is I'm assuming he has to disclose that fact.
Mhm. Well, if he's a personal rep, he doesn't have to fill out the condition report.
Right.
But it is a fact that would help everybody if it is made known. So he doesn't have to, but I think it would be smart for him to provide that information.
Can we provide it in the description?
Sure. What do you think, Steph?
I
I
always,
think. Go ahead.
I think that a real estate, if he knows something, like just because they don't have to fill it out, they still know of something.
Mhm.
So,
Yeah, especially in a condominium, because that's part of the documents that has been made known to all the unit owners. So that should be shared.
So he should fill out the condition report then?
He really doesn't have to fill out the whole report. He can fill it out and just attach that information.
Okay. We have
Because
two
it was-
estimates, so we could provide those to the potential buyer too, I'm assuming. Okay.
Joni, I do have the slides. Do you want to make me a
Okay.
host? Do you know how to make me a
Sure.
host? Okay.
How do I make you a host?
If you go to participants
Mhm.
and
Okay.
then, if you kind of go to the more, like hover over my
Mhm.
name and hit more.
Got it.
All right, awesome. Sweet.
Good. Well, we just have a couple of minutes and that really is all it's going to take for these slides.
Um,
Thank you.
yeah. Okay.
Okay. So basically, we're saying that a lot of this is a copy of what we've said in going through the condition report. But again, I want to just reemphasize. The broker's is to inspect. Now, this is your role as a listing agent. A property prior to listing it and to ask the seller for a written statement of the property condition report. The seller completes the condition report according to a state statute and the definitions in the RECR, which we went over, and the advice of legal counsel as needed. This requires the residential seller to complete the RECR, whether they are broker assisted or for sale by owners. So that means everybody in the state, when they sell, has to fill one out or risk rescission in the offer to purchase. The statute generally applies to all persons who transfer real estate 1 to 4 dwellings. So if you're into multiple units over 4 dwellings, this is not a part of it. You do not use a record for that. Generally applies to all persons who transfer real estate containing 1 to 4 dwelling units, including condominium units, timeshare, and living quarters. And then we review who is exempt. All personal representatives, trustees appointed by conservators, other fiduciaries, or subject to supervision by the court, but only if they have never lived in the property. So in your situation, Judy, this brother who is now the personal rep doesn't have to fill out the condition report, but if he ever lived there at any time with his brother, he does.
Yeah,
So-
and he never did, so.
Okay, good. And a power of attorney is not exempt from filling it out. Number 2, the real estate has not been inhabited, new construction, or the other exempt if it's between family members. Any transfer is exempt from the real estate. Transfer fee is not required to fill one out. If a seller claiming he or she is exempt, the broker, from completing it, the broker may review the refusal, this is the refusal form I was talking about, available in zip form, and ask the seller to complete that form. The form includes check boxes identifying potential exemptions. Once the seller, and this is important for you listing agents, once the seller provides a record, the licensee compares his or her observations and knowledge to the record. If there are inconsistencies or the licensee thinks the seller's disclosure are incomplete, as I said, missing any items or inaccurate, the licensee would make a timely written disclosure of material adverse facts as appropriate. So say you, the listing agent, you see something that is definitely a defect, the seller ignores it, won't do it, you have to put in writing a disclosure of that defect of material adverse fact, and it has to be a material adverse fact. Call Steph or me if you have any questions if this pops up in your listing. If the seller has never lived in the property but has received a pre-inspection report, so Judy, this goes to it, or any previous reports or evidence of work done, that information can be attached to the record or itemized on the condition report. Full disclosure of any information on the property protects the seller and the firm from liabilities. If a defect has been corrected, repaired, it is good business practice to record that information and the date of the correction So there's a paper trail from the seller. And that's pretty much what I had said too. I think that's it.
Mhm.
So that's our importance of the real estate condition report. And again, feel free to call Steph or me if you have particular questions on a property. You're either helping a buyer buy or helping a seller sell. Okay, have a good day, everybody.
Thank you.
guys.
Thank you, Steph.
Thank you.
Bye-bye.
See you next
Bye-bye.
week.